Mr. Chairman, thank you for allowing us to show that video. I want to drill down a little bit further on Mr. Koskinen's testimony to Congress, especially some of the statements made to Congress in June and July of the year 2014, when he came to explain why the IRS wouldn't be able to produce thousands of lowest learners' emails. At that point, a subpoena had been in place since August of 2013. The subpoena was reissued to Mr. Koskinen after he was confirmed, so by then the subpoena had had his name on it for more than 5 months. On February 2nd, 2014, Super Bowl Sunday, Kate Duvall realized that there was a problem with Ms. Lerner's emails and that some of them were missing from the IRS production to Congress. Ms. Duvall was counsel to the commissioner at the time, and she was basically managing the IRS production to Congress. The next day, on February 3rd, Ms. Duvall told her colleagues at the IRS about the problem she had found. She told the IT people. She talked to the people in the Office of Chief Counsel. She talked to the Deputy Associate Chief Counsel, Thomas Kane. And by the next day, February 4th, Thomas Kane had figured out that Lois Lerner's hard drive had crashed back in 2011, and that was why many of her emails were missing. So the IRS knew in early February that there was a problem with Ms. Lerner's emails. And Mr. Koskinen testified that he knew in February. This is his quote on a July 23, 2014 hearing, quote, "What I was advised and knew in February was that when you look at the emails that had already been provided to the committee and other investigations, and instead of looking them by search terms, looked at them by date, it was clear that there were fewer emails in the period through 2011 and subsequently. And there was also, I was told, there had been a problem with Ms. Lerner's computer." So the question is, what did Mr. Koskinen, under subpoena, do about it? After all, he had this subpoena. He had just learned that most crucial evidence covered by the subpoena was missing, and so you'd expect him to spring into action. Well, let's start with what he did not do. According to the Treasury Inspector General for Tax Administration, he failed to look in 5 of the 6 places Ms. Lerner's emails could have existed: the backup tapes, her BlackBerry, the server, the backup server, and the loaner laptop. In fact, the IRS barely looked for this missing emails at all, according to TIGTA. Now let's talk about what Mr. Koskinen did do. In April, his agency notified the Treasury Department and the White House that Ms. Lerner's emails were missing. And then he waited. And then he waited some more, until June, when the IRS finally told Congress by burying a couple of sentences in the 5th page of an attachment in a letter to the Senate Finance Committee. That was on June 13th, 2014. That triggered a flurry of hearings in Congress, and Mr. Koskinen came up to testify to explain what he said. And then he lied. We've got 3 quotes here I want to share with you, among many. But let's look at what he told us on June 20th in 2014. 7 days after finally telling Congress that Ms. Lerner's emails were missing, he said, "Since the start of the investigation, every email has been preserved. Nothing has been lost. Nothing has been destroyed." That's not true. The investigation began in May of 2012. The Inspector General found the IRS destroyed evidence, 422 backup tapes that contained as many as 24,000 emails to and from Ms. Lerner, and that happened on March 4th of 2014, which was discovered after they discovered there was a problem. And go to the second quote, if I could. This is on the same day, June 20th, 2014. Mr. Koskinen testified before Congress, quote, "We confirmed that backup tapes from 2011 no longer existed," end quote. That wasn't true either. The backup tapes were intact until March 4th of 2014, almost 2 years after the congressional investigations began, and nearly 1 month after the IRS knew there was a problem with Lois Lerner's emails. At best, this is gross negligence. We'll go to the third quote. To me, this is one of the most troubling. This is July 23rd, another full month afterwards, July 23rd of 2014. He was asked what was meant by the word confirmed. He said, "Confirmed means that somebody went back and looked and made sure that, in fact, any backup tapes that had existed had been recycled," end quote. That was completely and totally false. Nobody at the IRS went back and confirmed that the tapes had been destroyed. The Inspector General interviewed the people who were responsible, and they said that nobody had ever asked for the backup tapes. In fact, all told, the Inspector General, it took them 15 days start to finish to go find these, and they did recover 1,000 emails. Thanks, you can take that down. If they had done so after learning that some of the learners' emails were missing in early February, they could have found the backup tapes before they were destroyed. We know this because, again, the Inspector General only took them 15 days. Tim Camus, the Deputy Inspector for Investigations at TIGTA, summed it up by testifying, quote, "The best we can determine through the investigation, they just simply didn't look for those emails. So for the over 1,000 emails we found on the backup tapes, we found them because we looked for them," end quote. We're here today because Mr. Koskinen provided false testimony. He failed to comply with a duly issued subpoena. And when he knew there was a problem, he failed to properly inform Congress in a timely manner. In fact, I would argue that he actively misled Congress. Nor has Mr. Koskinen ever made an attempt to clarify or amend any of his prior statements. He continues to stand by all of these statements. They are not true. Look at the testimony that wasn't entered into the record. Sentence 3 of the testimony that he put forward, or tried to put forward here, says, "I stand by ready to cooperate with your committee with regard to any actions it deems appropriate." But I noticed that he didn't show up at the hearing here today, even though he was invited. And for him to say later on page 4, "I testified truthfully and to the best of my knowledge in answering questions concerning the search for and production of emails related to the investigation," he still doesn't get it.
Thinking to myself as Chairman Jordan was talking about kind of the history, the chronology of this investigation, as these two witnesses well know, there were, about a half dozen defenses offered by the IRS throughout the course of this investigation, each of which collapsed under its own illogic. It began with the two people in Ohio that were blamed, and then it went to my favorite defense, which was that the IRS is too incompetent to be able to construct a scheme as sophisticated as this scheme was, and then they moved from that defense to but we also targeted progressives too, so at least we were equal in our discrimination. And then my favorite, the one they settled on towards the end, was, but the president himself did not personally approve this targeting scheme. Therefore, you don't need to look at it anymore. I know the next hearing is about the process that, Koskinen mentioned due process in his opening statement that he didn't give to us. And the next hearing is about what processes do, the procedural part of due process, whereas this one is more of the substantive part of the due process analysis. And I am interested, as other members are, what elements need to be proven. What's the standard of proof? Is it clear and convincing evidence? Is it preponderance? Is it beyond a reasonable doubt? Does anyone know? Do the rules of evidence apply? Can you use hearsay? So I'm interested in that. But Chairman Chaffetz, you said something that I wrote down, which doesn't happen very often, but it did happen today, which is that impeachment is a penalty. It's a punishment. And you're exactly right. It is. It's a punishment. What Congress really wants is access to the documents and the witnesses, because that is the lifeblood of any investigation. You cannot conduct an investigation if you don't have access to the documents and the witnesses. We know that. Unfortunately, those who seek to not be investigated also know that. So until this body begins to incrementally assert itself with impeachment acknowledged being the ultimate penalty. By the way, I want to make sure, since I have two experts, one for sure, expert in front of me, and then the chairman of oversight, did I hear correctly that incompetence is not an impeachable offense? Because I always believe that malfeasance in office or the failure to perform the duties of your office could be an impeachable offense. Is that your understanding as well?
It can be a factor, yes.
So how can incompetence be a defense when the allegation is incompetence? If that's what we're alleging, I mean, it doesn't have to be a crime. The notion that you can only impeach someone who commits an actual violation of the criminal code is nonsense. There are lots of ways to screw up in your job that don't rise to the level of meeting the U.S. criminal code. So the notion, if I heard it correctly, that incompetence is a defense to an allegation of being incompetent, it's hard for me to get my head around that. All right, let me ask you this, either Chairman DeSantis or Chairman Chaffetz. Mr. Koskinen said every email has been preserved. Was that true or false?
False.
So if it's false, then the next line of inquiry was whether or not it would be intentionally false, negligently false, whether or not he had a duty to investigate but did not perform that duty. I guess that's what we want to investigate, right? Not the falsity of it, but the nature of the falsehood.
Go ahead, Rick.
Yeah, and I mean, you're a prosecutor. Now, these aren't criminal offenses, but you remember 18 U.S.C. 1001. A reckless disregard for whether a statement is true or a conscious effort to avoid learning the truth of a statement can be construed as making a knowingly false statement. And so we're in a situation here where, at best, he just simply refused to avail himself of the proper facts and came to Congress and testified under oath and made a statement that's just factually incorrect.
I also have a note, backup tapes from 2011 no longer exist. Was that true or false?
That is true. Now, they went back and they were able to find some,
Yeah.
but some were, as they call it, degaussed.
So it would be false to say they no longer exist. Clearly, they exist because somebody went and found them.
It's how you define degaussing, but some of them went through this degaussing process,
If
which
you're
is
talking about
essentially
degaussing,
destroyed.
you're losing.
Exactly, but that was their defense. That was what they suggested.
I mean, it's a little tricky because they destroyed a lot of tapes, obviously, but then there were other tapes that the Inspector General after the commissioner made the statement, they just hopped in their car, went to West Virginia, asked for tapes, and they found a bunch of tapes. And I think there were 1,000 unique emails that they were able to find off those tapes. So when the commissioner said that there were no backup tapes, at the time he said that was false.
Well, I know I'm out of time, Mr. Chairman, but I'm looking forward to the next panel because I am interested in hearing how incompetence can be a defense to an allegation of incompetence, and I think it would be the law professors that will have to explain that one to us.